Good evening. I'm Jill Bernstein, representing the League of Women Voters of Bellingham and Whatcom County. Tonight, we have Spanish language and Punjabi language interpretation available. If you're watching via Zoom, you may use the interpretation symbol on your screen and select either Spanish or Punjabi to hear the program in your preferred language. Members of the audience, there is not an opportunity this evening for you to ask questions. Questions have been submitted by the public and from League members before this, and so the chat function will not be available for your use tonight. The League of Women Voters was founded in 1920. The League is a nonpartisan organization with more than 700 affiliates in all 50 states. Our goals are to encourage informed and active participation in government, increase an understanding of major public policy issues, and influence public policy through education and advocacy. The League never endorses candidates or political parties. Membership is open to all people, men and women, aged 16 and older, and we invite you to join. Tonight's forum is being broadcast on the City of Bellingham's YouTube channel, on BTV also, and recordings of this program in English, Spanish, and Punjabi will be available on the League of Women Voters of Bellingham-Whatcom County website. You can find that at lwbellinghamwhatcom.org. The forum will be rebroadcast on Bellingham Community Television, BTV, through Election Day, August 2nd. No portion of this forum will be rebroadcast or may be rebroadcast in part or in full without the written consent of the League of Women Voters of Bellingham and Whatcom County. Questions for this forum, as I mentioned, have been prepared in advance by the League with input from the public. Cascadia Daily News, Linden Tribune, Salish Current, The Northern Light, and KMRE 102.3 Community Radio are our media partners. Tonight, we are hosting the candidates for the Whatcom County District Court Judge Position 2. The Whatcom County District Court has 2 judges, each elected to 4-year terms. The court hears criminal and civil cases, infractions, and miscellaneous other counties in the cases from the county. The judges decide administrative and general court policy. They preside over cases and hearings in this court. The current salary for the office is $193,447. I'd like now to introduce and welcome the candidates. Their names will be displayed on the screen, but they are Jonathan Rands, Gordon Jenkins, and David Nelson. Here are the rules that we're going to follow this evening. Each candidate may make a 2-minute opening statement. Then each candidate will be asked to respond to questions. They'll each get the same question. Candidates will have up to 90 seconds for their responses. At the end, candidates will have a 1-minute closing statement. I will ask candidates to speak in the same order as their names appear on the ballot. Unfortunately, we will not have a timer on the screen, and instead one of our members will be keeping track of the time that the candidates have to speak. When they have 15 seconds left, she's going to give them a warning, and when their time is up, she's going to let them know that they have to stop talking. If they continue to speak after their time limit, they may wind up with their microphones cut. Are there any questions about the rules, candidates?
No.
Okay, well, with that, welcome to each of you. And tonight we're going to start with an opening statement from Jonathan Rands. Mr. Rands, please begin.
Thank you for this opportunity to participate in this forum. My name is Jonathan Rands, and I've spent the last 20 years preparing for this opportunity to serve our community as district court judge. I spent the last 2 decades on a daily basis in our district courts, Whatcom, Skagit, Island, San Juan, and Snohomish counties. I have seen and experienced every kind of courtroom culture a judge can create. When the judge applies different rules depending on who you are or who represents you, or when that judge is in that position because of influence rather than being the right judge to serve the community, it undermines the entire process, thus undermining the true purpose of district court, which is access to justice and the rule of law. These two are inextricably intertwined in our systems. The true role of a district court judge is neither power nor prestige. Rather, it is service. Service to the community and providing equal access to justice and the rule of law. This is essential to the entire community. And this means the entire community, not just someone who looks like you or thinks like you or lives like you. I've been fortunate during my 20 years of practice in our district courts to have learned from several great judges who modeled the character and skill set for the job of district court judge. My reputation in our community is that of an incredibly hard worker with a vast knowledge. I look forward to pairing my work ethic, knowledge, and years of experience working with all kinds of people and members of our community with what those judges taught me, and to serve our community as your next district court judge. Thank you.
Thank you. And Mr. Jenkins.
Thank you. Thank you all for having me this afternoon. My name is Gordon Jenkins, and I'm running for district court judge because the breadth and variety of my experience will allow me to bring the most effective, equitable, and holistic approach to the district court bench. I'm a current senior deputy prosecuting attorney for Whatcom County, but I am a former defense attorney who focused on the representation of indigent defendants. I've handled cases ranging from minor traffic offenses all the way to homicide, and I'm very familiar with the broad range of issues that can arise in all the different kinds of cases. I have particular knowledge about the difficulties of domestic violence cases, and I have specific experience in therapeutic treatment courts dealing with addiction head on as the drug court prosecutor for Whatcom County. As the next district court judge for Whatcom County, I would be hoping to expand the use of therapeutic treatment courts in the district court. So many of the defendants who are coming through this court system are dealing with issues in their own lives, and each of them needs attention in an individual setting. And one size does not fit all when it comes to solving the issues of crime and recidivism and addiction and mental health. So it would be my goal to expand and add courts like a veterans court or a DUI court, or even just a general substance abuse court, to give as many tools as possible to both help defendants and then also help our community. I would also want to improve the efficiency of the court system. Cases take far too long to resolve. Defendants being under the thumb of the court for 1.5 to 2 years is far too long. There's far too much risk for the issuance of warrants falling out of touch with the court, and victims no longer have much of a sense of satisfaction when cases reach their conclusion.
15 seconds.
I have a broad and deep respect for the rights owed to defendants and those owed to victims, and I would bring those things and the respect to the court. Thank you all for your time.
And Mr. Nelson.
I'm Dave Nelson. Thank you to the League of Women Voters for presenting this forum. I was born and raised in Whatcom County and graduated from Ferndale High School. It's been my privilege to spend my entire career practicing in Whatcom County in our district court as a defense attorney, pro tem judge, and for the last 26 years as Ferndale prosecutor. As a result of this varied experience, I fully understand the law of district court. I also am the only candidate rated well qualified by the Whatcom County Bar Association and rated well qualified by the Whatcom Women Lawyers. I'm also shaped by my experience outside the courtroom. I volunteered and sat on boards at Lydia Place, Big Brothers Big Sisters, the American Institute on Domestic Violence, and the CASA program, Court Appointed Special Advocates for Children. My 35 years of experience have given me unique insights into the issues we must confront as a county: domestic violence, mental illness, and the jail stressors are significant problems that must be dealt with to ensure that our community has health and safety. Our courts must be creative in approaching these issues while maintaining accountability for offenders and compassion for victims. On June 13th, the jail went on restrictive rating. That means effectively there is no jail for misdemeanors except for certain domestic violence cases and DUIs. The next judge is going to have to deal with that issue. I bring creative sentencing solutions to district court, and that's what we're dealing with in Ferndale on a daily basis. I hope that you'll consider supporting me. Thank you.
So for our first question, we'll begin with Mr. Rands. And for each of you, this is the first question. Many voters express confusion over how to best choose between judicial candidates. How would you advise a voter to choose a candidate in a judicial election? What professional and personal qualities should they look for?
Thank you. I have the broadest view, approach, and understanding of district court, and I think that that is a very important aspect for voters to consider. This is a court where people seek justice in the application of the rule of law. Our community is bound together with the rule of law and cannot function properly without it. People seek justice for so many reasons and subject matters other than just criminal justice: marriage, name changes, petitions for a variety of civil orders, non-criminal traffic infractions, car crashes, slip and fall cases, to name several. Decades of experience is important, and I have decades of experience in this court on a daily basis, and it's allowed me to truly understand the human element when it comes to seeking justice in this court. I've worked closely for more than 20 years with people from all walks of life. I have a unique understanding of all the challenges that people face in access to justice. I understand the stress of attending court. I understand the time commitment it puts on people and the impact upon them. These are all considerations for voters to consider when selecting their next district court judge. I'm acutely aware of blind spots, implicit biases, and many other systemic barriers people face because for 20 years, I have fought through and navigated those with clients. A judge must be aware and understand these issues to ensure removal of access to barriers in order to ensure equal access for everyone. These are all important qualities that a candidate must have.
Mr. Jenkins, the same question.
Thank you very much. Voters should be looking for who has the broadest experience in terms of the cases that will be coming before district court. The range of issues that will be appearing before them are not in just a single area of law. They cover issues of addiction and mental health. They cover issues of domestic violence. They cover issues of procedure in all of these different areas. And a judge needs to have a broad understanding of all of these areas and have experience in the types of cases, not just a number of cases, but the different variety of cases that will be appearing before them. And I have that type of experience, having touched on all of these different types of cases. They should also be looking for a judge who has a deep understanding of using therapeutic court systems. The district court is, at its core, supposed to be a therapeutic court. These are cases that are going to be we're trying to address underlying issues for people, trying to address the mental health, trying to address the substance abuse problems. But it's not enough just to want to address those things. You need to understand how therapeutic court systems work. And I do have that understanding. I work directly on a weekly and frankly daily basis with treatment professionals in the drug court program. But furthermore, you need someone who is truly unbiased, someone who has seen the courtroom from both sides, someone who will not favor either party. And I have both the experience of a prosecutor and a defense attorney. Thank you.
And for each of you gentlemen, we've gotten word from the interpreters that they're having a little difficulty keeping up. And I know that you want to use as much time as you can to share your ideas, but keep in mind that the interpreters would like to share your ideas with the Spanish language and the Punjabi listeners who are with us this evening. And so, Mr. Nelson, please go ahead and answer the same question.
Well, I think experience is vital. My entire career has been criminal law. As a public defender, I was in district court. As a private attorney, I've been in district court, but also the courts of limited jurisdiction out in the county. City of Ferndale, I've been the prosecutor for 26 years. Before that, I was prosecuting in Blaine. And these are courts that original jurisdiction comes from district court. So the experience I have is with district court during my 36 years. I think it's also important to understand the culture of the community. I grew up here. I think it's also important to know, as a judge, as a pro tem judge, which I've been in every court in this community except for Ferndale, which you can't be a pro tem judge and a prosecutor in the same court. That would be a little unfair, but I believe that understanding how to hear cases in a way that has with manners, and understanding that people coming before you are afraid. Most citizens will come before district court. That's the court you're going to come before if you get into court.
15 seconds.
I think those are the factors, the demeanor and the knowledge and experience.
Thank you to each of you. For your second question, we'll begin with Mr. Jenkins, which is, there is concern about the use of jail to hold indigent and low-income individuals in jail while they are awaiting their trial date, and the effect that this can have on them, the community, and the needs of justice. Some communities have eliminated cash bail. Do you share these concerns, and what remedies would you propose to deal with these potential problems?
Absolutely share concerns with regards to holding people in custody purely because they can't afford bail. Bail is a means of absolutely last resort in all cases, but frankly, most importantly in district court, where all of the cases are misdemeanor and gross misdemeanor offenses. I think it is incumbent upon a judge to be looking for all types of avenues that they can to find alternative ways of making sure that the community stays safe, but that also that defendants are appearing before the court. I think that using pretrial monitoring systems to have people checking in with their attorneys, checking in with probation in a pretrial setting is certainly one avenue of going down that. Sometimes they can be connected to a family member to make sure that they're being kept up on their court dates. There always should be pursuit of alternatives anytime there's a concern about setting pretrial conditions. However, there are occasions where someone's safety is very much in play and all other matters or all other solutions have failed. Situations where domestic violence is in play and someone is on pretrial and violated no contact orders on multiple occasions, or where they're on their second or third DUI.
15 seconds.
And are continuing to drink and to drive. And in those occasions, sometimes there's nothing left but to impose some degree of bail. And in those situations, I do think it's necessary for a judge to be willing to do that.
Mr. Nelson.
The era of cash bail is over, effectively. I believe that. And the least restrictive means of creating safety for the community is the law. In truth of fact, there is no jail as of now for misdemeanor cases. Someone will be put in jail overnight for a DUI. Someone will be put in jail on a domestic violence case when they're arrested. But the jail is now on restriction to the point where there is no serving of warrants and there is no sentencing in the jail alternatives. The next judge is going to have to deal with this issue. The infrastructure at the jail is failing. The staff at the jail is insufficient. It's just the truth that there is not going to be a jail. So alternatives, that is what the next judge is going to have to deal with. That dialogue needs to start. And the entire philosophy behind the jail for the next term of office for that next judge is going to be alternatives. Work crew,
15 seconds.
Work release, community service, all these things are going to be in play. And that is the issue.
Mr. Rands.
I share concerns with bail. As a result of district court defendants allegedly being accused of crimes, they are the least serious, and we have a systemic approach that endeavors to keep them within the community. District court has a myriad of alternatives to holding someone in custody, but cash bail ultimately is not appropriate, nor is bail. The Supreme Court has by rule ordered district court judges to use the least restrictive means possible. This means bail as a last resort. Imposing bail generally means continued incarceration prior to conviction for our disadvantaged minorities and the economically disadvantaged. Most people cannot afford bail in any amount, unlike affluent people charged with crimes who generally have little difficulty posting bail. The court rule requires a judge to use discretion on a case-by-case basis and also be creative within the law to accomplish attendance at future court dates while being mindful of community safety. It also requires a judge to use existing resources to avoid bail. Bail is a last resort at the district court level. As a judge, I would hope to take advantage of every option available and avoid bail as its systemic bias and thus a barrier to access to justice. In serving as a pro tem judge in the last 4 years, I do this frequently. quite frankly, in my decades of
15
experience,
seconds.
there are few misdemeanor charges, if any, where bail would serve any purpose other than to punish. Even the most serious crimes prosecuted in district court have numerous alternative release conditions available in lieu of bail.
Thank you, gentlemen. And our next question will begin with Mr. Nelson. Please describe an instance where you faced an ethical dilemma in your professional life and describe how you resolved that situation.
An ethical dilemma. Well, the most obvious ones that happen in criminal law are conflicts. Because I have worn many hats, I have to be very, very aware of who is coming into my courts and who I can represent. Obviously, if I'm sitting as a judge out in one of the small towns and I encounter someone who I have previously represented, that is an ethical dilemma, and I cannot do that. It's not hard to bend the rules. And the trick is, as a judge, is to not do that. And I think that is actually the easier route. I've seen it too often where a judge will say, gentlemen, talking to the prosecutor and the defense attorney, I've represented this person. Does anyone have a problem with that? And they're laying the ethical dilemma onto the attorneys, the advocates. I don't believe in that. I think the judge should be saying to the parties, I have an ethical dilemma here. I'm taking myself off the case. We need a new
15
judge.
seconds.
That is my philosophy, is it not pawning it off on other people, but taking the responsibility.
Mr. Rands?
Thank you. Tough question to answer sometimes, simply because we all do our very best to work within the ethical bounds. And our ethics as lawyers are sometimes different than moral ethics that people expect of us. But as to the question is, can I think of an ethical dilemma that I encountered? The answer is yes. And the brief situation was where I represented multiple family members in different actions, but with their consent, as the rule allows you to do. The ethical dilemma that I faced with that was allowing my clients to choose their representation of choice. And as a matter of ethics, the first thing that I have to do is let each party understand and know that while I do have an ethical obligation to each of their defenses, that obligation is a problem unless waived, because sometimes what you learn in representation of one can be used against another. And that is not the role of a defense lawyer when maintaining confidentialities. So the way through this ethical dilemma is you sit down with the parties involved in this particular instance. You lay out, before you know too many facts of the case,
15 seconds.
what the ethical dilemma is, and you get the agreement in writing. And when that is done, that is how you resolve the ethical dilemma. It's not necessarily the best case, but sometimes it is what your clients want you to do.
And Mr. Jenkins?
Thank you very much. Prosecuting attorneys are held to a higher ethical standard even than other attorneys. There are specific rules dealing specifically with prosecutors that we are supposed to at all times be endeavoring to seek justice. And that can apply in any number of different circumstances. One of the primary ways comes in making charging decisions. And I have to make charging decisions on a daily and weekly basis as to whether or not to file in a given case. And making the decision not to file is always a struggle and a difficult one, particularly if I believe that someone has been harmed in a given case. But as a prosecutor, I am ethically bound to only charge a case if I believe that there is sufficient evidence to prove it beyond a reasonable doubt, not because I want to see someone receive comeuppance, not because I want to help a victim, but because I truly believe that the case is true and it is provable. And making the decision not to do that there are not facts, despite the impact that may have on a number of people's lives, is something that I'm always having to struggle through. But it is absolutely imperative to the overall function of our justice system. In the context of a judicial
15 seconds.
Judicial position, always be willing to do make it the unbiased and do what you think is correct under the law, irrespective of what the outcome may be or what you may think you want the outcome to be, is imperative. And I think that those two things are very related, being able to look past what the ultimate result is, what the correct choice is.
Thank you, gentlemen. And for the next question, we'll begin with Mr. Rands. What, in your judgment, is the role of a crime victim in the court in deciding whether a case should go forward, in deciding sentencing, and in any other way that the case is handled in the district court, including but not limited to cases that involve intimate partner violence?
Ms. Bernstein, would you be so kind as to please repeat the question?
I'd be really happy to. What, in your judgment, is the role of a crime victim in the court in deciding whether a case should go forward, in deciding sentencing, and in any other way that a case is handled in the district court, including cases involving intimate partner violence?
Thank you for the repetition. Multiple questions, so I hope I have enough time. Moving forward, well, first of all, the decision for the case to move forward or not to move forward generally is clearly within the prosecutorial discretion. Insofar as whether a crime victim has input in that, that would be ultimately up to the prosecuting attorney's office or agent to make that decision. So I guess the answer there partly is that I don't necessarily think getting to district court, a judge doesn't have any authority over that. And so when the case gets to the court, the role that I see a victim playing would simply be in sentencing or thereafter, or on a pretrial basis, mostly be between intimate partners. On a pretrial basis, the law of the land is that when there's an allegation of domestic violence, a no contact order has to be imposed against the party that is the aggressor or the alleged aggressor. And a judge certainly has to follow the rule of law in that. In a pretrial basis, when a victim of a crime comes forward and wants that removed, I think a judge has a very important role in assessing
15
what
seconds.
wants to be done and the community safety or the individual safety of that particular person. With respect to sentencing, crime victims have an absolute right to address the judge prior to sentencing.
Mr. Jenkins.
Thank you. So it is true that the state or the prosecution has the ultimate decision as to whether or not to prosecute a case, irrespective of what the specific desires of any individual victim may be. I do think it is certainly incumbent in making that decision as to how much that should go on. The prosecution usually does need to take into account the truth and the reality of the domestic violence cycle and what can occur out of that. That sometimes individuals who are still in danger may not wish to seek prosecution of their cases, but as that is not the ambit of the judge. That's not the place where the judges are making decisions. In one place where the judge is making a decision in relation to that is setting conditions of release and dealing specifically with no contact orders. And again, in that situation, understanding sometimes that the domestic violence cycle will cause people to come in and request rescissions when there is real danger still in their lives, because even misdemeanor offenses can be indicators of much larger problems at home, and a judge needs to be aware of that in making decisions regarding sentencing, or excuse me, regarding conditions of release. With regards to sentencing, victims have an absolute right to be heard, and I think it is certainly important for the court to take into consideration the impact that a particular crime has had on any individual person and the community at large. Thank you.
Mr. Nelson.
Well, 14 days ago, the law changed, and we're dealing with that in Ferndale, where now on domestic violence cases, victims are mandated to be heard by the court at sentencing. And that means that even if someone enters a plea of guilty, the victim in a case needs to be notified and given the opportunity to speak. So that also means that there's going to be sentencing hearings separate from a plea, because now the law is that a victim will speak if they want to, or present a written statement. Now, we staff these cases as prosecutor in Ferndale The judge isn't involved in that. The judge is going to be involved in mandate, following through on the law regarding requiring someone to be heard. But as to prosecuting it, we staff these cases, and yes, the victim has a say. The victim's rights advocate is my go-between between the victim and the prosecution. But each case is looked at on an individual basis. So yeah, the victim is an important component in prosecuting the case, but now even more important in sentencing.
15 seconds.
That's
Well,
what I have to say.
Gentlemen, I'm sorry, that's all the time we have for questions. And now we have to move to your closing statements. And Mr. Rands, will you please begin with your closing?
Thank you. At the end of the day, I'm a longstanding member of the community who wants to serve at a broader level than my practice allows. I'm asking for the opportunity to serve because after more than 20 years of practice as a trial lawyer in our district courts, I have the understanding, experience, work ethic, and commitment to ensuring access to justice for all people who come before the court. I ask for this job because our judges should come from and should be the very best the legal profession has to offer. I believe I am that. I have a belief in the rule of law without forgetting what it's like to see our community members struggle with addiction, homelessness, poverty, employment, and other quality of life circumstances leading to various minor crimes. I'm passionate about improving our court and community by bringing a restorative justice program in the form of a community court. I'm committed to ensuring equal access to justice for everyone by being aware of blind spots, systemic barriers in the form of privilege, race,
15
and other
seconds.
bias. I'm ready for this responsibility, and I ask for your vote. Thank you.
And Mr. Jenkins?
Thank you all again for giving me your time here today. In closing, I have broad experience from both sides of the courtroom that has given me a profound understanding and respect for the rights and duties owed to defendants, as well as the needs of victims and community safety. I will improve and expand the use of therapeutic court systems in the district courts so that we will be better able to address the needs of each defendant and break the cycles in their life. I will improve the efficiency of the district court so that cases do not drag on and hold people under the yoke of the court system for longer than is necessary. I will respect every individual who is before me and speak to them on a human level as is deserved by all people. I will always remain cognizant of the risks of implicit bias in my own life, my own thought processes, and the system itself. I'm supported by Sharon Shoemake, Satpal Sidhu, and other leaders in our community. I ask you all for your support as well and your vote in August and in November. Thank you.
And Mr. Nelson?
Well, thank you for taking the time to learn about us local candidates. I know the district court judge race may not be the flashiest race on the primary ballot, but district court handles the misdemeanor cases in this community, including domestic violence and DUI. So it's an important court. You're in this community. I believe that with 35 years of experience as a prosecutor and as a defense attorney and as a pro tem judge, I will bring accountability with compassion to district court. I've been endorsed by Whatcom County leaders. I've been rated well qualified by the Whatcom County Bar. Superior Court Judge Rob Olson is supporting me. Ferndale
15
Mayor
seconds.
Greg Hansen is supporting me. And former Bar Association President Rajiv Majumdar is supporting me. So I'm asking for your support. Thank you for hearing us all. I appreciate it.
On behalf of the League of Women Voters, I thank the candidates sincerely for being here today and for their interest in running for public office and serving the community. Voters, you can find more information about the candidates online at vote411.org. That's vote411.org and in your voter pamphlet. Ballots for the primary race will be mailed on July 13th of this year. Your ballot must be postmarked or in a ballot box, drop box before 8:00 p.m. on August 2nd. Please remember to sign the ballot envelope, and if mailing by postal service, we recommend that you mail early. And thank you all for your interest in what is really an important race for our community. Thank you all.